Say welcome to everyone. Thank you so much for joining us today. For those who don't know me, my name is Rohi. I'm the program director for JNF Toronto. And today's webinar is co-hosted with Wise Law, and it's Legally Adulting, Legal Issues a Pandemic Throws Your Way. So just for the next couple of weeks while everyone's at home, JNF Future, which is the young professional sector of JNF, is putting together many workshops and webinars such as this one, just to keep everyone engaged, keep everyone connected. Either if it's an activity or an discussion, we'll hopefully be bringing it to you guys. So I'll just give you a little bit of info about our hosts today. So Paul, Adam, and Simran Bakshi. A little bit about Paul, who's waving his hand. Thank you, Paul. So Paul is a lawyer at Wise Law Office. He practices civil litigation, including commercial, human rights, injury, and breach of privacy matters, as well as estates, including last wills, power of attorney, estate planning, estate administration, and contested. So in addition to his law practice, Paul has lectured at schools, the Toronto Law Association, the Parliament of World Religions, and other forums. And outside of work, he can be found cooking, spending time with family, and is active in Toronto Partnership Minion and the Jewish community. So thank you, Paul, for coming here.
Thanks, Rohi.
And a little bit about Simran, if you want to give a little wave. So Simran is an associate lawyer at Wise Law with practice focused primarily in employment law, family law, human rights, and civil litigation. In addition, Simran also holds an honors bachelor's degree in business administration with a specialization in finance and international business from the Schulich School of Business at York University. And Simran contributes to family law topics for the Lawyer's Daily publication and is a co-host of Wise Law's Legally Adulting Community Seminar being brought to you today. In addition, Simran also serves as a clinic director at a wellness clinic called Nirvana Wellness Center. And when she's not working, Simran enjoys spending time with her family and friends and taking every opportunity to travel. So with that, I'm going to pass it off to Paul and Simran to tell you a bit more about legally adulting.
Thanks a lot, Rohi. And thanks to everybody who was able to join us today. We're excited to be sharing this webinar with you. I wanted to start out by just telling a very brief story about the last time that I was, let's call it, in the field on one of the files that I was working on. The last court or sort of meetup between me and an opposing lawyer on a file was a mediation that I did. I had to go back and look through my calendar to figure out when this was. And I was looking at dates from, mid-February. I thought it must have been at least 6 weeks since the last time I was actually out of my house and doing something. And then I was looking and I realized that the event that I'm talking about happened on March the 13th, which was about 3 weeks ago. And I think that speaks a lot to how everybody is sort of like experiencing the concept of time right now while we're all in our own homes. But anyway, this was a mediation. The place that we usually go for mediation is usually like overflowing with people. The kitchen is usually jam-packed. All of the meeting rooms, of which there are about like 40, are usually jam-packed. And on the day, I think we were one of 2 events that were taking place at that mediation place. We had found out earlier that week that the courts in Ontario were suspending all jury trials and all matters in which there was a jury for criminal matters. Then earlier that day, during the mediation, we got an email informing us that the Ontario courts were shutting down all small claims matters. And then the next Monday, we got an email saying that just all court functions were being suspended until further notice, except for filing. And then the Monday after that, we got another note from the court, which said, no filing either. The courthouses are just locked. Nobody can come in and use the courts for anything in Ontario. And the fact that all of those things, from like just suspending some jury trials to, nobody can file anything at the court, nobody can basically use the courts in this province for anything, happened in the space of about 2 weeks, from 60 to 0. And I think that's indicative of how much the game has changed. so quickly in this province in response to the COVID pandemic. If that mediation had been scheduled on the next business day, like the Monday instead of the Friday, I think it probably wouldn't have happened at all. And I think that, you know, the speed with which the situation changed speaks to a lot of what this this COVID pandemic has done to a lot of the everyday sort of assurances and certainties that we have about our jobs, our families, our own health and our well-being, and the health and the well-being of other people in our lives, our ability to collect money that's owed to us, our ability to pay money that we owe to other people, and just, you know, some very quotidian things like where we're going today when we get up in the morning. Are we going for a run? Are we not going for a run? Are we going to work? How are we getting to work? And I think a lot of people, sometimes myself included, are sort of fumbling around for a sense of certainty and control over, you know, what we're going to be doing with our lives today or this week. We started this this seminar series, Legally Adulting, as an exercise in demystifying the process of gaining control, a sense of control over your own legal rights, and your own ability to advocate for yourself, and demystify the process of talking to a lawyer about getting your legal house in order. And we thought that with this particular webinar, we could take some time to help people demystify the process of consulting with a lawyer, you know, right now in the spring of 2020, in a moment where so many of the rules that seem to govern our everyday lives are, you know, on indefinite hiatus, it can feel like, and to work through thinking about the process of what everybody can and should be doing to address problems that are coming up. And, you know, potentially with the assistance of a lawyer that you're consulting with, how to use this moment as an opportunity to first remind yourself and then remind other people about what rules governing how people are employed in the province of Ontario, what rights employees have, what rights you know, renters have, what rights you know, family members have with one another, which one of these rules are still enforced, and what we can do in a situation in which the old rules can no longer seemingly be reasonably implemented because of the COVID-19 crisis. And in a situation where the old rules don't seem to apply for the time being, how to propose some fair ground rules for yourselves and for others, and how to really try to set the tone for, you know, how people are going to deal with you and how you're going to deal with other people in the next couple of weeks, months, however long this crisis lasts.
Yeah, well, just to add to what Paul's saying, what we're really hoping to accomplish here today is to start a dialogue. You know, what are the questions and concerns that we as young people have about living through a pandemic? You know, let's talk about these questions that are keeping you up at night. You know, what's happening with my employment? It seems to be in limbo. Are you thinking about your wills and your estates? Are you wondering how you're actually going to pay the rent next month, or your mortgage, or how to keep your business afloat? You know, contractual obligations. What happened to that contract you signed March 1st? Is that still in play? Your relationships with your family, who you may or may not be seeing. You know, it's going to have an impact on your spousal relationships, or your parental relationships, or childcare. And that list will just go on and on and on. I'm sure you guys can all add something to that as well. And I'll be completely candid with you. A lot of the questions you're going to have for us today, there just are no firm answers right now. This pandemic is, of course, very new to all of us, and everyone from the government to our public health officials to even our courts really don't have a script to be working off of right now. They are taking it day by day and coming up with solutions as they get a better understanding of what this problem is. So then what is our goal here today? We are really looking to approach your questions in two different ways. to first kind of talk about what is that legal framework that used to be in place, if I can call it pre-pandemic, like what was that baseline that we used to work with? And then kind of shifting gears to probably the more important consideration, which is what can we do now? Like what is that practical next step we should be taking right now? As Paul describes it, you know, how do we set the tone for living through this pandemic right now? Now, as much as there are a lot of negatives that obviously come with the COVID-19, it's also a really interesting time to be living here, because our experiences and what we're going through are really going to be a part of this society-wide conversation about what we do next. You know, everyone is listening, from the government to, you know, experts, our employers, industry leaders. Everyone wants to know, you know, what has your experience been? How do we find the solution collectively to this pandemic? So it's a really interesting time where our voice gets to be heard as part of this society-wide conversation. And we'd really like to hear from you on that note as to what your questions are and what your experiences have been, and anecdotes that we can all share with each other. So on that note, I'm going to turn it over to you guys to see what questions you might have for us.
So actually, we did get some questions in beforehand, so maybe we'll start with one of the pre-asked questions. And just to let everyone know how we're going to do everything with the mics is we are asking if, you know, in between questions, you can keep your mic quiet, just for any background noise to keep that quiet. And then if you have a question, just unmute your mic and ask the question, or feel free to type it in the comments if you prefer that. So our first question we'll open it up with is, your thoughts on completing an affidavit regarding application of probate during COVID-19?
So this is a really interesting question. Just to give a little bit of background, for almost all court filings that happen in Ontario, and specifically for ones that you need to make when you are applying to be appointed as the legal representative of a person's estate, you need to file some kind of a sworn statement that the court can look at as evidence in order to make a decision about, you know, in this case, appointing a person to be the legal representative of an estate, but which means the person who will be responsible for distributing inheritances from that estate to all the beneficiaries. But also equally, these are kinds of documents that you can use, you know, if you're applying for, you know, if you're applying for custody or access to a child, or you're, you know, filing a complaint about, you know, an unfair workplace practice, or, you know, a human rights issue. All of these kinds of sworn statements need to be typically signed in the presence of a witness, and then the witness needs to sign next to your name. And when typically we talk about the statement being signed in the presence of a witness, up until about March of this year, that was interpreted by the courts as being like in the physical presence of a witness. You're in the same room as a witness. What the Law Society did, I think to its immense credit, almost as soon as this pandemic hit and people stopped going to work, was they issued a sort of a practice note saying that, you know, for the next however long this sort of crisis lasts, the Law Society's official position is that when we talk about the presence of a witness, they will accept a document that is sworn without the person who's signing the statement and the witness being in the same room as one another. And what that's going to mean is that a lot of lawyers are probably going to be arranging Zoom calls just like this one with their clients to sign all kinds of documents, like sworn statements, like, you know, for example, in any family law matter with the court, at a certain point, you need to sign a financial statement about what assets you own. And it looks like for the time being, the courts are going to get around this by allowing lawyers to virtually view their client signing a statement. The lawyer will then, have the client probably send a copy of that affidavit to the lawyer by courier, or the lawyer is going to sign a separate statement saying, I witnessed my client, Simran, sign this statement, and I identified my client by comparing her picture of herself to a piece of identification that I have on file, and then that'll be filed with the court, and the court is probably going to accept that. I think this speaks to a broader question, though, about, how much stock do we really put in this idea that, a document is valid just because a person signed it in the presence of a lawyer. There are all kinds of things all kinds of sort of hanky-panky that can go on with wills that are signed in the presence of a lawyer that cause those wills, down the line to be contested in court. A lawyer may be witnessing somebody sign a last will when that person didn't actually have the capacity to sign the will. The lawyer may not have done enough due diligence to ensure that the person signing the will, isn't being pressured to sign it by another person. And one of my hopes is that what is going to come out of this crisis is that the courts are going to, and the Law Society are going to go back to first principles and rethink, what makes a document valid? What do we need to assure ourselves that a document is true, and that it says, and that, the person who was signing it took some time to actually think about what the document contains and whether they agree with the statements in that document before they signed it. I think that the idea that meeting your lawyer in his or her office and signing the document in the presence of the lawyer means that the document is therefore somehow true and incorruptible, I think is like a nice but a sort of antiquated idea. And I am hoping that some of the practices that the law profession adopts in this crisis are things that are going to carry forward, and that it won't always be necessary to physically meet with your client if that client lives in Vancouver, let's say, to sign a legal document, just so that a judge can be satisfied that the person, understood that they were signing something that that had to be true and not false. That's my thoughts about it. Simran, do you have anything to add to that? I know that there are a lot of things to sign in these kinds of statements in the family law context too.
Yeah, no, I definitely agree with what you've just said. I think if anything else, this pandemic is making us rethink how can we do things a bit more practically without necessarily having to go through formalities that have been in place for a long time and for good reason, but we've never really had to give it further thought because we've never been forced to do so. So it's really interesting to see, because we're on the files that we're working on, as an example, we're starting to see lawyers try to collaborate and come up with solutions with, I know we've got to do this technically, but now that we've got all these limitations, what can we actually be doing? So as an example, with family law, you do have to sign financial statements, and you've got to affirm it or swear it to be true. And what we're seeing a lot of people doing at this point is to say, well, let's do this in draft form. Let's actually get the ball rolling and see what the financial disclosure is. And yes, at some point we do need to ensure that the parties are swearing to the truthfulness and the completeness of these documents. But for the time being, let's at least start with step one, which pre-pandemic you probably wouldn't have seen at least not as routinely as we're seeing it now. So I always say that there are some silver linings to this pandemic, and one of it is that we're just being forced to think about things a little differently and be more creative.
Yeah.
Maybe I can jump in with a couple of comments on this. Simran, you described a necessary rethinking ahead. I'm not sure it's so much a rethinking as a reprioritization ahead. I mean, if you look at what we're all doing right now with video conferencing, this is the courtroom of the future. It's actually the courtroom of the present. I follow quite a few lawyers on Twitter, and bail hearings are now being done by video conferencing, just like what we're doing right now. I'm actually not sure what platform they're using, but right now, people's future in terms of whether they can get out of very dangerous conditions in jail um, are being deliberated via video conference. And one of the discussions I saw on Twitter today was whether lawyers should be robing for these video conferences or not. And before we started, we had a little conversation about what people should be wearing for even this kind of a conference. And but it's quite interesting. The reality is that these kinds of technologies have been available for between 5 and 10 years to allow people to do exactly what we're doing in a court context. Similarly, we've had documents sent to us via email by the courts for eons of years. Every time a judge makes a decision, they actually send the decision to lawyers via email. But for some reason, we're not allowed to send our documents to the court by email because that's considered insecure. And the broad point that I'm making that I think is coming up in many discussions is the technologies exist to take a lot of the inertia out of the system. This pandemic is forcing those technologies to come to the foreground. And not only is it going to translate into easier access to justice, it's actually going to eliminate a whole lot of costs. And just for our viewers, you know, one of the things that happens when we go to court to speak to a matter, it could be a motion, but not a trial, but another court appearance before a judge, is typically we get placed on a list of anywhere from 5 to, in Newmarket, 40 or 50 cases. And the lawyers literally physically wait around in the court waiting rooms until their case is called. And in some jurisdictions, 4:30 comes around and your case hasn't been called, so you're sent home and told to come back another day. If the court would actually start scheduling many of those appearances by video conference, just like this, the lawyers would only be spending 20 or 30 minutes having their case dealt with and be free to work on other matters. Clients would not be billed for all that waiting time, and the whole entire system would work more productively. So I think that discussions that have been ongoing by those of us who kind of like technology and care about technology, those discussions have been ongoing for at least 10 to 20 years. Now suddenly the court system is faced with the reality that they have to adapt. And the former Chief Justice, Beverly McLaughlin, made comments about that just yesterday, that this is forcing the court's hands. And now it's time to catch up technology-wise in a way that we've been dramatically behind for many, many years. And that, I think, is one of the good things that will come out of COVID in terms of the administration of justice. So let's keep our fingers crossed that these kinds of experiments that we're participating in right now in this conference are going to be adapted in the legal industry, but in many industries, to increase efficiencies, to reduce people's costs, to make things go more quickly, and to take some of the inertia out of the system. Okay, my rant is finished. Thank you for your time.
Yeah. The only thing I would add to this is that I think that, you know, one of the things that I think society is going to have to reckon with after this crisis is over is how much of an essential service internet connection is to everybody in the province of Ontario. And, you know, it used to be that everybody was entitled to receive mail service in their home. And, you know, I think that society has really been lagging behind in understanding how many people do and don't have access to a stable internet connection, and how much, you know, in addition to just being able to access the court system, you know, how much it means it gets easier for people to do things like pay their bills, or, you know, be able to have a job that they can that they can go to and earn a paycheck from at home. I think that the legal system is going to have to use its weight to push the government of Ontario and the government of Canada. It's the government of Canada because it's a telecommunications issue, but to level the playing field so that everybody can have access to the kind of technology that we're using right now, so that everybody actually can have the ability to participate in a court hearing from their house, in a work meeting from their home. I think it's going to open up not only the justice system, but the economy to more people who were really cut off from it, if the investment in this kind of infrastructure is made, over the next, hopefully 3 to 5 years to decade.
And if I can just share one last thought on this, I know there's a lot of questions that have come in about employment law matters and wills, and so we definitely will get to that. But the only thing I would add to this is I'm really interested in seeing how much of what we've adapted during this period of time is carried forward, and how much of it just kind of reverts back to, things were working fine before all of this happened. We're going to go back to just business as usual. And I'm hoping that what we learn now about being collaborating a little bit more, cooperating a little bit more, adapting to technology, that sentiment really carries forward. And we see it not only in just access to justice, but really in all aspects of our lives. It's been really wonderful to see people kind of come together to try to find solutions here. And I'm hoping that kind of, in our world, we call it ADR. So trying to find a resolution that doesn't necessarily involve litigation. So trying to work with each other on a different level. And, you see this in other aspects of life as well. You see landlords and tenants now talking to each other and trying to find that middle ground. You see municipalities deferring taxes on properties in an effort to try to help people. And I really do hope that carries forward as well.
Mm-hmm. Some great insights. Thanks for sharing, guys. So I'm just going to open the floor quickly to anyone who's tuning in currently for any comments or questions on that. Otherwise, we'll take one from the questions that were sent in. Okay, so let's just move on. So there was actually a question that may apply to a few people here. I'm not too sure, but one question that was sent in, and I'll add it to the comments so people can read it as well. The question is, I'm currently self-employed, but have been working under a contract with a company. I fear they are going to cancel the contract due to coronavirus. Would I qualify for EI?
So that's a really good question. And typically with EI, it's only available for employees. And there's all these criteria about how to actually get those benefits, including the fact that you typically have to be without work for 7 days. You have to have certain hours to allow you to qualify. Typically there's a 7-day waiting period. And we're seeing that kind of change to adapt to the situation. With self-employed individuals, you're probably not going to still be entitled to EI, but very recently we've heard announcements of a different benefit program. It's called the CERB, and I'm going to definitely mess up the acronym, but I believe it's Canada Emergency Response Benefits, which you would be entitled to as a self-employed individual. I believe it's up to $2,000 every 4 weeks. And right now, the commitment that the government has made is for at least 16 weeks. So that would definitely be an avenue to explore. And that benefit program should also be available to people who are employees, people who are just unable to work in any capacity because of their childcare or caregiving responsibilities. So it applies to quite a few different groups, but definitely self-employed individuals as well. We don't have a lot of details about how this is going to look just yet, but I believe they've given a commitment to have some more information sometime this week or early next week, and you probably are going to be able to apply by the week of April 6th.
Simran, can I ask you something of a follow-up on that?
Sure.
I know that you're our sort of resident employment law guru. I know that a lot of civil contracts sort of not in the employment context, in like, let's say a construction context, will have a provision that will allow one or the other party to get out of the contract in the event of like a force majeure event, in the event of like a sort of an act of God situation, when one or the other party isn't able to fulfill its obligations due to circumstances beyond their control that like weren't anticipated when the contract was signed. Like, how prevalent do you find those in employment contracts, and how might people use that in a situation like this?
That is a really, really good question. So we typically don't see force majeure type of clauses in employment law contracts, but there is an equivalent common law principle, which is known as frustration of contract. And that just doesn't apply only to employment law. It actually applies overall to any kind of contractual relationships. Now, what frustration means is that it's very similar. It's a party or both parties are unable to fulfill their end of the bargain because it's just legally frustrated. In the employment law world, we've seen this before where an employee unfortunately has a really long-term disability and have not been able to work for years and years on end. And at some point, the employer will say, well, your end of the bargain is to be working for us, and you haven't, unfortunately, because of your disability, been able to do that. So we're going to consider this contract as having been frustrated, meaning it comes to an end. But interestingly, when you claim a frustration of contract in the employment law perspective, the employer, because you're severing that employment relationship, still typically has obligations to the employee that would come about with just the termination. So they still, at the very minimum, have to pay what the Employment Standards Act requires of them, which is termination pay, and where you've got a very long-term employee working for a larger organization, some severance pay as well. So that's typically how the law of frustration would work. Now, whether the courts are going to give employers a bit of a break on this, just given the circumstances, is really up in the air, but it's something we've had quite a few discussions on. And it's something that I suspect the courts are going to weigh in on this to say, perhaps employers don't necessarily have to pay those severance obligations, or perhaps we can treat frustration not so much as a permanent thing, but more as a temporary thing, which you can often see in the more civil context where you've got that force majeure type of provision. So I suspect that there are going to be a little bit of changes and some tinkering to that, the law of frustration, but right now, what we know in terms of just how this is played out generally is that yes, employers at a certain point, once that threshold is met, can rely on frustration, but would typically have some obligations applicable.
If I can jump in on this one as well, Simran, what do you think the courts are going to be considering in determining whether a break is going to be given, as you described it, to employers? How do you think judges are going to look at this at the end of the day, assuming there's no legislation before we reopen to cover this off?
I really think there is a bit of a push right now to try to get employers to continue to employ their employees to the extent that that's possible. And I think that that's the key, to the extent that it's possible. So I have a feeling they're going to really look at the nature of the employment relationship. Like, was this a relationship that could have continued on with certain adjustments, working from home or work sharing programs? Was it possible to make that employment place of employment safe for the employee to be working, or was it just impossible? So I think I don't think it's going to be an automatic break for employers. I think the courts are really going to give some consideration, probably on a case-by-case basis, about how impossible was it really to be carrying out that employment relationship, either temporarily or, permanently. In some cases, we're still seeing some terminations as well.
Well, let's look at a situation where it's clearly impossible. We've been consulted by a bunch of dental offices that were essentially mandated to close by their governing body, the College of Dental Surgeons of Ontario. So they were in a position where it essentially would be professional misconduct for them to stay open, and you don't need your regulatory body to know that this is not the time for two humans to be that close together in a professional context. So dentists have had no real ability to stay open except for emergency services. And when looking at what dentists were permitted to do in terms of layoffs, for those who are here with us today, basically an employer is allowed under the Employment Standards Act to lay off employees for up to 13 weeks, particularly if there's an employment contract that permits it. If there is no employment law that permits it, in ordinary times, maybe not. Maybe there is no entitlement to lay off, but let's leave that secondary question aside. What that means is that if you're not returned to work after 13 weeks, you're deemed under the Employment Standards Act to have been terminated. And if you don't have an employment agreement that permits termination, permits layoffs, you can take the position you've been terminated. So the real question is what happens in 13 weeks if the employer cannot yet call somebody back because there's still a close down and your dental office can't reopen. So that's question number one. Will the statutory termination be in place? The second question is for those who don't have contracts permitting layoffs. If they say, forget it, I don't accept this layoff and take the position I've been terminated, are the courts going to back up those people? And I think it's going to be an interesting balancing act. My view is that the Ford government needs to create some legislation that answers these questions because they're going to affect literally millions of workers potentially throughout the province. But we have some real serious question marks right now. I don't think the court has the resources to deal with them on a case-by-case basis. So I hope that the provincial government is going to legislate some kind of balancing. But my concern for employees is many businesses are going to go out of business and their ability to get any severance payment or wrongful dismissal damages is going to be very compromised. And they simply may have no recourse if the companies they work for can't reopen. And alternatively, the courts are not going to saddle employers with millions of dollars of severance obligations that will shut them down in the event that we return and people don't want to come back because they'll take a technical position that they've been terminated. So I think we have a lot of very interesting questions ahead in the employment law world. And, we're already seeing the catch-22s that employers and employees find themselves in. And hopefully we're going to be able to thread the needle and find solutions. The good news is that where we've where we've recommended to our clients that they correspond with employees to request the employees' consent to layoffs, meaning taking away all of these issues, the employees have 100% consented. The employees have been on board, employers and employees are working together to find solutions. And hearkening back to Simran, your comments earlier, I think we're seeing a spirit of cooperation and collaboration in many circumstances that it's a pleasant revelation that we're seeing it. There are other circumstances, like Amazon workers who are going on strike asking for more money, where I'm not sure where the sympathies are going to lie at the end of the day. But let's all keep in our thoughts all those essential employees, the people who are working in hospitals and grocery stores and gas stations to keep the world going, because they're taking tremendous risks themselves to keep our lives as close to normal as possible. And I'm quite sure that we're going to start hearing some legal issues relating to that down the road too. But let's keep those people in our mind. I'm sure all of us know people who are in those circumstances, and we know on a personal level what it means to be on call in a hospital right now, what it means to be getting a grocery store ready for Passover right now. And a good friend of ours works for one of the grocery stores in Jewish Toronto, and this was the week where they would ordinarily transition the Jewish aisles into Passover, to Pesach items. And you can imagine the complications of doing that under these circumstances, but those people are really out on the front lines, and I'm sure they all have our admiration and support. But if you know them personally and you know the personal stories that are involved, it's really something what these people are doing. And kudos to them all, and may they all be safe and carry on well. So thank you.
And if I can just add one thing, I think we've talked about cooperation and collaboration, and I think another principle that mix is accountability. I was just reading a family law decision yesterday where the courts were trying to consider the question of, is a parent allowed to not follow through with access as has been ordered by the court previously if they've got concerns about the child's well-being with leaving the house to go see the other parent. And it's an interesting decision because the courts essentially say there needs to be a balance. The parents really need to think about what is going to be in the best interest of the child. And as much as ongoing contact with both parents, it's definitely very high up there. The physical well-being of the child and leaving the house also needs to be really seriously taken into account. And reading the undertones of that decision were really parents need to work together to try to come up with a solution that's going to work in the circumstances for their family. And what I really took away from that decision, and actually the judge very explicitly said it, is that at this time we need to be accountable. We need to, it's not as easy to run to the courts to ask for some guidance because with the exception of emergency matters, they're just not able to hear these things. So it's when it falls down to us alone, we need to be accountable for coming up with a practical solution that's going to work in the best interest of ourselves, our families, those around us. And that's going to be a very interesting time to see how that actually works itself out.
Are you hearing anything from clients on these questions yet, Simran?
I've got a couple of queries about that. I know I had a client who is an essential worker, still needs to go to work, and has primary residency of her daughter. And they come from a very litigious background with this family law file being, there's some undertones of domestic abuse and things along those lines. So, handing over her daughter to her former partner was not the most comfortable option available to her. But it was something that she needed to give some real thought to because at the end of the day, if she's being exposed to potential health risks, it's something that there's a bigger picture here to be seen as to what happens, what's the best childcare arrangements for her daughter at this point.
Simran, I actually got a follow-up question back to the employment law question that was asked just a few minutes ago. So what should a person really be asking a lawyer if they are thinking about consulting on an employment question like this? Like what are the steps that need to be taken? What should the questions that need to be addressed?
Yeah. Well, one thing employers are really not supposed to be doing this time is having their employees be in just limbo. Like there should be some thought given to, am I laying off this employee? Am I terminating them? Like, what is the status? Because that's going to have some implications on the kinds of benefits you can be claiming here. So as an employee consulting with a lawyer, as a first step, really some background information about what have you been told by your employer in terms of what's happening with your employment. You might not even know the answer to that because your employer may not have communicated that to you, but that in itself could be a problem. As a baseline, just seeing what your employment contract actually provides for is really helpful. So maybe sending over a copy of your employment agreement, as well as any recent correspondences you've had about what's going to happen in the days ahead. Would be really helpful because what we're trying to determine when we speak with you is is it a situation where you're still working and you don't feel safe to do so? Is it a situation where you're not working and you really have zero clue as to why it is you're not working? Is it a situation where you're both really on the same page about it not being safe to work, but you don't know what your options are with regards to benefits and what your employer's entitlements are in terms of how long they can carry this forward for? So there are different types of issues that come about, and the more clarity you can provide your lawyer with, the better, because we can kind of explore exactly what your concerns are.
Okay, great. Thank you. Just another question that was sent in that's a specific one. So the question is, so my friend's job today told him that because of the crisis, they need him to work his full workload, which is 5 days a week, but that they'll only be paying him for 3 days worked, basically working 40 hours for the pay of 24 hours. Is this legal?
In short, no. If they were to reduce your hours and you're working less hours because of the crisis, that would be a different story because you're still being paid for the time that you're putting in, but your employer can't basically have you work for free. That's at this point, at least, there's nothing that would allow that. So I would strongly suggest, firstly, speaking with a lawyer about it, but secondly, the solution may be maybe there is a work sharing type of program that should be in place here. Are there other employees that can pick up some hours rather than that individual working 40 hours and getting paid for half of that? Is there another solution possible that's going to meet all the concerns on both sides of the table there? But in short, an employer can't basically have you employed without actually paying you for the work that you're putting in.
Okay, thank you. Good to know. I'm just going to open it again if anyone joining us would like to say anything. Otherwise, I'll ask another question that was sent in. Okay, so I'll just jump right in with another question we got. So the question is, my immune system is compromised due to previous cancer treatment. My work refuses to let me work from home, even though that would be a workable setup. Is it protected under disability?
That is a really good question. So there are two ways to really look at this. Firstly, the Human Rights Code does protect certain grounds, including disability. So if you need some accommodations from your employer, up until a point of undue hardship, they are legally obligated to be accommodating you. And in a situation, as you've described, where you are able to work from home and that presumably allows there to be continuity with the business, you're starting to get to that point where it's really not undue hardship from the sounds of it for an employer to allow you to do that. So from a human rights perspective, yes, your disability is protected. The other aspect to be looking at this question is also the Occupational Health and Safety Act, which basically obliges employers to be providing a work environment that's safe and healthy for their employees. And if a lot of employers are probably hearing this from their employees, if they just don't feel safe reporting to work because of what's been going on here, they can actually legally refuse to attend at the workplace. And the act is very clear that they really shouldn't be disciplined, terminated, no kind of adverse actions should be taken as a result of the employee's refusal to work in an environment that they don't feel safe to work in. Now, the Occupational Health and Safety Act does kind of mandate certain steps that are to be taken once an employee refuses to work, and that includes some kind of an investigation. But what'll be interesting to see is how strictly those provisions are going to be upheld, or is the courts basically going to say, you knew this COVID-19 virus was spreading and that this was a genuine concern and it was legitimate, you should have accommodated the employee by having them work from home or not having them work at all, rather than doing an investigation into the matter. So practically speaking, the kind of investigation that's necessary in the circumstances, I think we're going to have to see play out. But the principle remains that an employer does have to maintain a healthy and a safe work environment for their employees. And where the employee feels that that's not happening, they are legally entitled to refuse to report to work on that basis.
Now, I'd like to return to the topic of accountability in relation to this question. And the first thing I'd really like to emphasize, folks, we have to be accountable for our own health, and no job is so important that you should expose yourself to any risk. And if you're immunocompromised, that's the only priority that matters. You take care of yourself, and let's have faith that we live in a system that is going to protect employees who have done so. If you need to stay home for health reasons, everything you see in the news is stay at home, Don't go out, stay at home, don't go out, especially for people in that circumstance. If you're working for an employer in a capacity that is capable of being done on a work from home basis, I don't know what the courts are going to do, but I can tell you we're going to fight very hard for any employee who suffers any kind of adverse consequence as a result of a decision to protect her health by staying home. So just don't worry about what your employer says. Worry about what's good for you, what your doctors have told you, and the rest of it will take care of itself down the road. So that's number one. And the other point I would want to add is it's contextual, of course, because the only people who we're talking about now are people who are in essential industries. Everybody else has to stay home, essentially. And if you're in the kind of industry that remains open, for, you know, hospitals as an example, it may well be that there's more onus on you to be there than there is if you're working in a variety store or a grocery store. And we know of physicians who've, sorry, that's my phone, gotta turn it off. We know of physicians who actually have had COVID. They've recovered, their symptoms are gone, and they're back at work, and we're hoping that their immune systems are now somewhat better protected, and they're not going to catch it again. But again, does a person who's had COVID have to return to work after recovering is going to be a whole different interesting question. But again, your health is the only thing that matters, and make decisions based on that. We'll handle the rest as best we can. I believe we live in a system that recognizes justice, that protects people, and I don't expect that the courts are going to come down terribly hard on people who make legitimate decisions for legitimate reasons. People who create illegitimate reasons may be put to the test on that. And good faith is necessary for employers and employees alike. But for now, if you don't expose yourself to any risk, even if your job says you have to. If you need to, speak to your doctor about it. But the most important thing for people in that situation, keep really, really good notes of every interaction you have with your employer. If you're doing it by telephone, try to do it by email so you've got an actual paper trail. But if you're doing it by telephone, make a note of the date, the time of the call, who you were speaking to, if there was more than one person on the call, a full note of everybody who was there, and as best you can, verbatim transcript of every single word that's said in the call, particularly words that are urging you to do something that aren't in your interests, and your responses to protect yourself in the call to explain why you can't do step X or Y that's being asked of you. And when you've got those kinds of records, that'll really help us down the road if you need some assistance from us.
And by the way, it is not necessarily illegal in Ontario to record a telephone call without informing the other person that you're recording it. Definitely, especially in the employment context, that is something that you should always consult with a lawyer before doing, because it, you know, for reasons that are easy to imagine, you know, surreptitiously recording a phone call can sometimes have a very negative impact on the employment relationship. But, you know, depending on the situation, and I think, by the way, this also goes for, you know, if you're having a dispute with your residential or commercial landlord or anybody else to whom you owe money or who owes money to you, you know, you may want to consult with a lawyer about your rights and whether it is so a good idea in the circumstances to consider making a recording of a call without necessarily informing the other party. You know, a lawyer may be able to tell you whether that's an option that that may be open to you, and that you know, that may be a way to gather evidence, you know, for use down the line.
And the only thing I would add to that is there is a lot of cooperation happening here with, you know, as an example, employees and employers agreeing to a layoff, even though that may not be specifically set out in your employment contract. If you are reaching an agreement during this period of time, the one recommendation we would definitely have is document that agreement in writing, and you want to be very clear that it's only applicable during these emergency times, extraordinary times really, and that the expectations as set out in your employment contract would remain going forward.
Mhm. Okay, well, thank you so much, guys, for that really, really insightful information. Unfortunately, we do have to wrap up since we're just about 2 minutes to 1, so that's all for today. But thank you, everyone at Wise Law, for participating, and for anyone who has further questions, we'll be sending out contact information for Paul and Simran if you'd like to get in touch with them directly. And again, just to mention what Gary said earlier, stay healthy, be smart, be safe, and thank you, everyone, for participating today.